Good evening, and thank you for joining us for CBS News Detroit at 7. I'm Shayna Humphreys. Tonight, we're going to take you to day 2 of the Miller hearing of the Oxford High School shooter. This hearing will decide the fate and whether or not a life without parole sentence is appropriate. Our Gino Vici was in the courtroom all day long. We're going to send you to him now.
Just when you thought this hearing couldn't get any more emotional, the assistant principal, as you heard, testified. Christy Gibson Marshall testified that she knelt down beside the body of Tate Meir, laying on the ground lifeless as she tried to revive him. The family broke down. Gibson Marshall also broke down, and she said she came face to face with the Oxford shooter moments later in the hallway and asked him what is going on. He ignored her and walked right by with a gun in his hand. And across the courtroom, the defendant showed emotion for the first time since being inside of a courtroom. He began to cry. Keenan Gregory also took the stand. He was inside the bathroom where the Oxford shooter shot and killed Justin Schilling. Keegan thankfully was able to escape. He now has a tattoo with 4 halos on his arm with Roman numerals of the date of the mass shooting. One of the halos is red, symbolizing that Justin Schilling saved his life. And more tears and cries from family members inside that courtroom as he described his encounter with the Oxford shooter.
When he moved the gun away from his side, kind of, I ran behind his back and out the door.
Okay. Why did you do that?
Because I think when I saw his body, I realized that if I stayed, I was going to die.
The prosecution rested their case just before lunch today. The defense spent the afternoon interviewing their experts, but Judge Rowe says this hearing should wrap up on Tuesday, but it's possible a decision will not be made for days, potentially even weeks. Reporting outside the courthouse, Oakland County, Gino Vici, CBS News, Detroit.
Thank you, Gino. Joining me now is former Wayne County Circuit Court Judge Vonda Evans and an attorney who is a leading expert on these Miller hearings here in Michigan, Sanford Shulman, as well as former Wayne County Prosecutor Todd Flood. Thank you all for being here today.
I feel like I'm back at Third Circuit. Todd was my prosecutor at one time, and Sanford had me get reversed most of the time. So I feel like, all I need is my gavel.
Well, I'm so appreciative that you are all joining us today. This is a lot to take in. This is a lot to witness as this Miller hearing continues. Sanford, I'd like to start with you, since this is your forte. For our viewers who are just joining us, can we talk about the point of a Miller hearing and what will be determined?
Well, Miller hearings didn't exist until the U.S. Supreme Court said that juveniles cannot be sentenced to mandatory life automatically. Before that, a sentence of mandatory life was really just cut and dry. And it was, if someone was convicted or pled guilty to first-degree murder, it was mandatory life. But the Supreme Court said that juveniles aren't mature, their brains haven't developed, and so they said before a judge considers a mandatory life, they also have to consider something less than that. 25 to 40 years is what the Michigan legislature said. So that's what the Miller hearing is. But in this case, what makes this particularly interesting is that the defendant is only been in custody for about a year. Most Miller defendants have been in custody for decades. Mm-hmm. So the defense has a huge file of prison records to show what he's been doing, what he or she has been doing, remorse and rehabilitation and programs. He doesn't have that in this case, so that's why it's challenging. But the real untold story is the judge, because the judge has to decide whether to impose a mandatory life sentence or something between 25 and 40. And that's the real story, because this is wrought with emotion. This is probably as emotional as you get. Mm-hmm. Your segments, even watching parts of it, is wrenching. But the judge watches the whole thing, and he has to be unbiased. He has to be detached. Mm-hmm. And yet, he still has to make that determination. That really is part of the story, and I think that's the untold part.
And there are these factors you mentioned that have to be proven, and the burden of proof is on the prosecution. Todd, what is their goal? What picture are they trying to paint here?
This man doesn't have a conscience. He's for all practical purposes, someone that would be a serial killer otherwise, right? So when you think about this, his home life, yes, he comes from a sad tale of woe. Mm-hmm. All right, I give. The DNA's there, but that's not the rest of the picture. Think about more. They got to be able to show. The big question, I think the judge hit on this earlier, rehabilitation. Can he be rehabilitated? And candidly, when you look at all the factors in this case, when you look at as the judge takes in his discretion whether or not he goes with the life without parole, the premeditation, the fact that he kills for pleasure, he wants to seek pleasure in pain, those demonic thoughts of finding some pleasure in killing another human, to me, you got both the environment, you have the DNA. I understand that there may be questions about, redeeming him, but I don't see it. Yeah. I don't see a shrink. They put a shrink up on the stand today, the defense. I listened to that, and it was about general topics. It wasn't specific as it related to this shooter. It wasn't specific I examined him and I found that this was missing.
You think that was by design?
No, I think that the fact of the matter is they didn't have it. They didn't have the facts and the absolute evidence to show that he could be rehabilitated. That's key. And Sanford's point is you don't have a history with him. You don't have a history in prison with him. But candidly, what is his cause to kill? You may kill somebody because he's coming after your husband and you do it in self-defense. That's a good cause, right? What does he do? He kills to get pleasure. To me, I don't see the redeeming quality in that.
Sure. The shooter's mental state is, of course, a factor, and we heard at least one psychologist or psychiatrist today say that he suffers from depression, the shooter. Barring any other mental illness, there was also a certain wherewithal there. There were time and time again we have heard he said he knew and understood that he would spend the rest of his life in prison. So, Judge Evans, would that factor in at all if it were your decision to make? Is that something you can consider?
Well, I think that you have to look at what he's saying in the eyes of a juvenile. You can say anything, and then that reality comes, and what do we see? Him start to cry, okay? I think that he looked at it and made a determination, but the reality, okay? I've seen grown men fall out when they get sentenced who thought that they could accept it. It's hard. This is a young man who's, according to doctors, there's not been sufficient brain development in the part of the brain to appreciate the wrongfulness of their behavior, to weigh the pros and cons as an adult would. Weighing pros and cons is different from a child than it is from an adult's point of view. Okay, I think that we can all agree on that. And so this Miller hearing factors in the cognitive limitations of someone who is his age. And it's not just for him, it's generically, it's brain development.
Sanford, whether we are talking about a juvenile or even an older person, isn't it so difficult to prove, to predict in any case how someone's going to be decades down the line?
Yes, and that's why the defense has that uphill battle. I mean, Todd makes an easy case for the emotion on the victim's side with the family there, and they have witnesses, and the defense has what? I mean, they have some experts who don't have much of a record. So that's the challenge. But in the Miller hearings that I've handled, that was the same person that Todd saw in that chair today, but 30 years later, 40 years later. They were mentors, they were teachers, they went to church, they did astounding things in prison. And now they get a chance to get redemption, and they go before a judge, and the judge can feel the emotion and grants the motion, and the person walks out. The point is, this judge is making a decision not just on this defendant today, but potentially forever. I mean, 20, 30, 40, 50 years henceforth. A mandatory life sentence. And that's the challenge that the judge has to say. You judge him today, I can see it. But how do you do perspective in terms of rehabilitation and redemption? That's the challenge in this case. How do you find that?
And the challenge is that he doesn't get another chance, okay? The other appeals that he have, they don't look at this. That's done. It's one and done. Whereas people who have been in prison for 20, 30 years, they have a plethora of information that they've rehabilitated. And so it's really presumptuous at best to be able to say he cannot be rehabilitated.
No, I take issue with it. If you just go with the whole year of him being in jail, you know what he looked up? He looked up how to be famous with this killing. He revels in the fact with this killing. he looked up in somehow, some way, you know, this younger generation, he got a backdoor way to get onto the internet with his iPad. And he starts Googling life sentence, can I get life sentence, and then reveling about the darkest spots of this. So I get it. I'm always want to give a chance. I give Karen McDonald credit for this. 19 cases she's reversed life sentences for with Miller hearings automatically from the previous regime. She takes this case, and you know, we can all tell, Democrats, Republicans, she takes this case serious, and she wouldn't be asking for life without parole, I think, unless she crossed all her T's and dotted all her I's. That's just my thought.
We do have to take a quick break, but the conversation continues right after. Stay with us. Welcome back. We continue our coverage of the Miller hearing that will decide the fate of the Oxford High School shooter. Today was day 2. The judge will eventually decide whether this teenager is eligible for a sentence of life in prison without the possibility of parole. It was another extremely emotional day in the courtroom. You're about to hear some of the testimony from some of the students who took the stand today, and because they are minors, we will only hear their voices. We do want to warn you that some of what you're about to hear is very disturbing.
What did that hallway look like?
It was chaos. There was someone trying to be resuscitated, and whoever was helping her was just yelling at her, like, come on, you get this, and stuff, trying to just get her to respond.
Do you remember where that blood was in relation to his body?
Around his head.
Okay. And the shooter tells you to do what?
Kind of signals me to go over by his body.
And what did you do?
When he moved the gun away from his side, kind of, I ran behind his back and out the door.
Okay. Why did you do that?
Because I think when I saw his body, I realized that if I stayed, I was going to die.
Just truly heart-wrenching testimony both days of this hearing so far. That last student, Keegan Gregory, was a freshman at the time when 4 fellow students were killed and 7 more people were wounded. Here with me today are Judge Vonda Evans and attorneys Todd Flood and Sanford Shulman. Let's talk about the nature of this testimony. It is so difficult to listen to. Judge Evans, I'll start with you. How much of a factor does that play in the judge's decision? Can it sway the choice here?
Well, it's very emotional. Being a judge is akin to being a doctor. You got to focus on what your job is. And that is to weigh those factors, to give respective weight to everything, and to make a decision. And you're a technician. That's what I would tell my jurors. You are you can't be, moved by emotion. Yes, it's there, but you got to make a decision on whether or not the prosecution has met the elements, in that case, beyond a reasonable doubt. And this is what he's the trier of fact. So now his job is to determine whether or not the prosecution has met the elements beyond clear and convincing standard, which was what needs to be shown. So he's acting here as more of a technician than being human and letting emotions sway him. But it is a consideration.
He's listening to it in a different way than all of us at home might be. Todd, you've been a prosecutor before. What is the goal of the prosecution? It's not just to put on a gruesome show, of course. What is their goal in having the victims sort of relive this experience on the stand?
A good prosecutor would say due process. Let's just make it fair. I'm going to put the facts out. I'm going to do it right. Here's the law. Here are the facts. I'm going to present this to the court, and I'm going to let due process dictate. It's the judge, and Judge Vonda Evans, one of the great ones. She called it as she saw it, and she said the ground was heavy, and it was a difficult decisions that she had to make. Can't be swayed, but the fact of the matter is that a prosecutor in this particular case wants to present clear and convincing evidence. All of us wear white hats. There's no black hats in that courtroom. Defense attorneys and prosecutors, we all work in a fishbowl. Everyone sees what we do. So prosecutor's going to get up there and make sure that all of the evidence is presented to the court in a competent way to show all of the factors. That what you're seeing there in the testimony that took place was the circumstances surrounding the homicide, both pre, during, and after, right? He even talked about in his journal, when I do this, I'm not gonna shoot the police. I'm gonna put that gun down. I don't want to get killed. I'm gonna put that gun down. I'm gonna revel in this stuff. So it was clear those are circumstances that go to the mens rea, to the guilty mind, to show how he maturely thought about all the facts and circumstances around the case. That's one. Prosecution's going to show that. Prosecution really delved, I think, heavy into the facts and circumstances of this case, as opposed to some other things they could have done. I wouldn't be surprised. I wouldn't be surprised, and I'll leave, I know Sanford and the judge will call on this one, but I wouldn't be surprised if they had a rebuttal witness of a psychiatric clinic report come up and testify as to why rehabilitation is a dim prospect.
And let me just say this to you. The prosecutor, McDonald's, been a judge too, and I believe a prosecutor. So she's worn all these hats. She's dotting her I's and crossing her T's. She's doing a phenomenal job.
Sanford, when are the alarm bells going off for you? When you're listening for those factors, you know what the judge is listening for. What kind of testimony do you think is the most useful when it comes to the judge's decision? Have these factors been met?
It's a very challenging one that you have to humanize your client. You have to humanize Mr. Crumbly, and that's difficult. And so when Todd references his conduct in jail, I would argue that reinforces his immaturity. That reinforces his brain hasn't really developed. If he's still conducting himself like a child, not like a sophisticated criminal, that would reinforce his whole demeanor as immature and really undeveloped. But I always wonder, what happened if this hearing happened in 30 years from today, as many of mine do, or 40 years? That would be a different Crumbly sitting there. It would be a different record. And while it would invoke the emotion from the family again, it would also bring out things about him that we don't know yet. Because when we're talking prospectively, will he be rehabilitated? Is he redeemable? We do know his family life was terrible. We do know that the circumstances around his growing up. And while people will dismiss it and say, I don't want to hear about him, I don't care about his issues, we got bigger problems. We have the picture that Todd painted. But the judge has to look at not just the facts and circumstances of the case, but for the defendant's characteristics, his growing up. What did he go through? What did he have to experience? And it's very challenging to have to empathize or maybe sympathize or empathize with the defendant. Yeah. You don't want to. Your tendency is to, make him a monster. But that's not the judge's job. That's not what the Supreme Court did. And that's not why we're having this hearing. The hearing is to determine what is appropriate.
You have to remember the Supreme Court, when they made the ruling in Miller, and then we followed it up with Taylor, you have to understand then it was a retroactive. You had to automatically give the Miller hearings going way back when we sentenced juvies. Today, it's standard practice that if you want to sentence a prosecutor wants to ask for life without parole, because the presumption is that you do get parole, you can't be sentenced to that. You have to ask for it within a certain time frame. So the majority of cases today that are in Miller hearings are the ones that are being sentenced for capital first-degree murder. Those happen all the time today. When the Supreme Court, the United States Supreme Court, came out with it, they said, hey, listen, you're going to have to come up with a program, as Sanford has done many, many times, and re-sentence all of those people in the Department of Corrections that were sentenced as juveniles to life in prison. So that's why you look at the 30-year standard. Not today, not today. Yeah. If you murder somebody as a juvie, prosecutor has the right to ask for life without parole.
All right, we're going to take a quick break, and we'll be right back after this. On November 30th, 2021, the convicted Oxford High School shooter killed 4 of his fellow students and wounded 7 other people. Today, court adjourned for day 2 of the shooter's Miller hearing, after which the judge will decide if life without the possibility of parole is an appropriate sentence. At the hearing today, we heard from students, psychologists and psychiatrists, and the assistant principal who said at first she could not believe that the shooter would be capable of something so horrific. She went on to describe how she tried to save one of the victims, Tate Meir. We'll listen to some of that testimony now with a warning that it is disturbing.
Were you making any, did you feel like you were helping him?
I just kept talking to him,
And what were you saying?
that I love him, that I needed him to hang with me.
Chrissy, what color was he?
It was blue. But when I was giving him breaths, he was getting lighter, so I just thought they were helping. So I kept giving the breaths.
How long did you do that?
I could taste his blood. There was so much blood. It was all over me. It took me a long time, months, probably almost a year, to get the taste of Tate's blood out of my mouth.
It just shows you how, beyond the victims who were killed and injured, it is such a traumatizing event for an entire community. There are so many victims of this heinous crime. Our guests are still with us, of course. The hearing will resume on Tuesday when the defense will continue calling witnesses. In some of that testimony, we saw our first and only glimpse of what appeared to be some emotion from the shooter. We can only assume what may have been going through his mind. What role might that play in the judge's decision, the courtroom demeanor of the defendant?
Well, obviously, it's going to make a decision, his accepting responsibility. And that's one of the things that all judges look at. Is this a person who is in a position that they really feel bad about what they've done? And as Sanford has said, it makes you, retrospectively. He didn't think that he would feel bad at that time. But then when you step back, it does play a part. But, as a prosecution would say, too little, too late. You had an opportunity not to do this, and you inflicted this pain on everyone, and you've got to be responsible.
How often, Todd, have you seen in a courtroom where someone truly has no remorse? Is that something you've encountered?
Yeah, there has been, for sure, all of us have. All three of us sitting at this table have seen people, that have come to the courtroom that haven't had a conscience or remorse. None of us have seen this. None of us have seen this. I've watched this video at length. It's the most disturbing. It'll lay an indelible imprint in your mind if you watch it from beginning to end. If you see those and juxtapose the text messages with it and the stories with it. I think there was an emotional response by the shooter here with this particular vice principal because the two of them had she taught him, I think, in junior high, and there was a relationship there at some point in time. You see in the video, she actually says to Ethan, as Tate is right there, she actually says to the shooter, "What's up? What's going on?" and uses his name. He turns his head to the left to look away from her. This is when he's coming out of the bathroom the first time, to avoid her, and then goes on more of his killing. So there was a connection between those two, and he showed it there. I don't think that'll have much of an impact on the court. I think it'll have some. I think it'll show something to the court, but I can't imagine that it gets the defense back over their burden once the prosecution has rebutted the life without parole standards.
Sanford, what might the defense's strategy be from here on out?
It's a challenge. You need to redirect the focus to Ethan and his growing up, to what he experienced as a child and what led him to this situation. You need to focus on his juvenile status, how he would think, how he would react. I mean, in courtroom, he shows some emotion, I understand that, but the whole thing is he seems to still look at everything as an immature person. And that's the problem, and that's why the Supreme Court has required these hearings, is it's a child. I mean, no matter what, a child who killed children, it's a terrible situation, and it strikes at us at the core, because here he's not even reacting what we think is sophisticated. He's this child sitting there. Now, people don't want to hear that. We want people to be adults and accept their responsibility. He pled guilty, and that's where the defense needs to show that he is a juvenile. The first factor of Miller is the age of this individual and their maturity, and it talks about his characteristics, and then rehabilitation. The Miller factors, 4 of the 5 talk about the defendant. So the judge really needs to focus 4 out of 5 on the defendant. And that's a challenge for the defense, to make him human, personalize him against the weight of all this. And that is where the defense needs to step up and say his attributes, his characteristics. Don't deem it necessary to give him life without parole, that he dies in prison. He is redeemable. That's the theme of the defense.
Does the home life, the unprecedented nature of the charges against the shooter's parents, does that complicate the prosecution's case? Does it help the defendant?
I think it helps the defendant. I think it shows that they didn't, if they had been the type of parents that maybe showed him more direction, showed him more guidance. But this is not a game of blame. But the point is, this is a sentencing here, when you're looking at everything. He didn't, what was his circumstances at home? What was his characteristics? That's the second prong of Miller. And it was so important to the conservative U.S. Supreme Court, to that conservative Supreme Court, that they want these hearings to proceed. So a very conservative Supreme Court, not only in Miller, made it so the juveniles can't be sentenced to mandatory life, but the continuing Supreme Court made it retroactive. And the Michigan Supreme Court in Stovall said that parolable lifers should also get hearings. Parolable lifers are now getting hearings, who have been doing 30 and 40 years. Huh? We're reevaluating how to treat children and how to treat prison life. And that's what this case is really about. Because in the past, it would have just been a formality.
Mm-hmm. Would you put him on the stand?
I would prepare him for that, but probably have an expert, through an expert, talk for him and demonstrate what he said and what he did. It would probably isolate him from cross-examination and also give the expert the ability to articulate the his comments, his conduct in a more professional manner by doing that. But he may allocute at sentencing. It's also not subject to cross-examination.
Is there any chance we see him on the stand? Do you expect that to happen?
I would think, this is kind of the roll of the dice. I would never put him on the stand myself. I would have an expert speak for him. But this evidence and testimony has been so damning.
Including the audio of his own voice.
Yes. If you have nothing to lose, and he's coached well enough, and you think he's competent well enough, because he had to be competent to take the plea, and I heard his allocution at the plea, and it was quite good. He was actually very good. So I think that could be a possibility. They don't have Sanford Shulman representing them, and I, sincerely, one of the best. I've been with him for a long. I've been with him for a long time, but I can't think I would do it as a defense attorney, putting him up on the stand. I would probably have an expert speak for him.
Yeah,
absolutely.
But ultimately, it's his decision, and he has to make that decision. But do I think that it would be in his best interest? It's hard to say. But I do think that, ultimately he's going to make the final call like he did when he allocated. And I think that he'll probably will take the stand in this one.
Well, we will find out as soon as Tuesday. Thank you so much to former Wayne County Judge Vonda Evans, former prosecutor Todd Flood, and Miller hearing expert Sanford Shulman. We really appreciate all of your insight.
Thank you for inviting us.
Thank you.
Absolutely. And our coverage will continue. But of course, we want to take a moment to remember the 4 students who did lose their lives back on November 30th, 2021. Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. 6 other students and a teacher were also wounded in the shooting, and we want to keep them top of mind. Our coverage of the fate of the Oxford High School shooter will continue next week, with proceedings resuming on Tuesday. You will be able to view the hearing as well as more expert insight on the air and streaming live on the CBS News app and Pluto TV.